Why should you establish a settlement strategy? Well, I think it's worth pulling back and thinking, what is settlement? And a way to think about it, I think, is it's just the negotiated form of dispute resolution. If you have a dispute or a claim, there are four potential outcomes. Either the claim is admitted, great, obviously, if you're the claimant. The claim is dropped, great if you're the defendant. Someone decides the outcome for you, let's say that's the judge in court, or you reach a settlement, and that's it. It's going to end in one of those four things, and you need to consider the viability of all four. Three of them are voluntary for either one side or both, and the other one, the decision is obviously voluntary for neither of you. So you need to consider how your dispute is going to end from the outset. And I should say these comments broadly apply whether you're the claimant or the defendant, although there are nuances depending on the exact situation. So the first thing you think you need to do is make an early merits assessment. This is probably the very first thing you'll think about. How is this dispute going to end if it does go to a decision? It's never too early. It takes a lot of time and effort to do this, but it is very valuable from the start. It obviously overlaps with the litigation analysis of your case from a litigation perspective, but it's the starting point for any settlement strategy. You need to get on top of the key facts. If there's a contract, you need to read that contract, understand the relevant terms. You need to look at all the key documents and the evidence. Maybe you need to interview a few people to find out what's going on, and you need to understand the law that's applicable to it. That's all the starting point. And at this point, you need to be objective. You need to be realistic, not overly optimistic. You shouldn't be overconfident about your chances at this stage. You need to take a cold, hard look at it. If you're going to lose, or you stand a good chance of losing, you need to factor that in from the outset. As you're looking through this, you need to look at the potential outcomes. What is the dispute going to involve? Obviously, there's the subject matter of the claim. Is it going to involve some financial element or damages? Are there going to be costs implications? How much is this going to cost in terms of external legal spend, but also the commitment of management? It could be quite a sort of fact-intensive, management-intensive case. It might not. You need to think about how long the dispute is going to take. Is it going to take you a long time to either get your money if you're the claimant or get the outcome you want? Or if you're the defendant, do you see actually an eventual judgment as being years away, in which case that's something to factor in. You need to consider the external outcomes of the case. So there's things like publicity and reputation. Is this dispute going to emerge, and what will it mean if it does? Does it involve any kind of business disruption? So for the business, for your stakeholders, for personnel, are there going to be fallout from an HR perspective? And are authorities going to be interested in this? Obviously, from a regulatory perspective, there's the regulator, or maybe even worse, maybe there are criminal authorities that are going to be interested in all of this. And you'll need to form a view at an early stage about the likelihood of each of these outcomes and the scale of these outcomes. And once you've done that, you need to work out what your objectives are and what settlement outcomes fundamentally might be better than those outcomes. So you think, if I ended up in this particular state, is that going to leave me better off? And that will allow you to shape what kind of a settlement you may want to end up with. And you need to weigh up the prospects of each outcome, what you want to gain from it if you're the claimant, and what you could avoid if you're on the defendant side. You also need to bear in mind, we've been talking about litigation. As Donna says, we should always be contemplating litigation. It's tremendous, but there are limits to what you can get from a court. Obviously, you can get damages and you can get a financial outcome. You may need to go to court to get specific performance or some injunctive relief or something like that to compel a party to do something or to prevent them from doing something. You may want a declaration as to your legal rights. You can get that from a court. You may want vindication in public. You may want factual findings or a binding precedent. You may want a judgment if you need to enforce. But there are limits of what a court can get you. It will be limited to those kind of things, and a settlement could offer you a lot more in terms of continuity of the business relationship and shaping the outcome in other ways. You also need to consider who is in this dispute. That sounds quite a sort of simplistic thing. Obviously the parties, but there are other people. Are there individuals within you as a party or your opposite number who are invested in this or personally implicated? You need to think about the effect on them. There are internal stakeholders whose interest you'll need to balance, decision makers, if that's the board, for example, HR, if there are personnel involved, your business lines, if this is the consequence of a fallout of a business relationship, then the commercial relationship and your business lines will be interested in all of this. Severe financial implications, obviously the CFO and related people, and also other group companies. If you're a subsidiary, to what extent will the parent company be interested in all of this? There are also external stakeholders, your investors, other contracting parties. I've mentioned reputation, but there's your broader customer or client base. Don't forget also the effect that a dispute might have on future talent. I've been in a number of disputes involving a dispute between either the founders or the managers of a particular business and the investors on the other side. If you're about to sack your management team because you don't like what they've been doing, what effect is that going to have when you try to replace them? And then you need to work out what your reasons are for settling. And these are really the flip side of the outcomes. You know, what can you reduce? Can you reduce cost? Can you reduce the time of the actual dispute? Can you reduce publicity or liability? And there are things from settlement that will increase, such as the certainty of disposing of the dispute, commercial relationship, and the freedom to get on with your business. And of course, you need to keep this all under review as you proceed through the dispute, because interests and incentives can change. And you need to consider it from your opponent's perspective as well. A lot of it will overlap, but sometimes your opponent's incentives and objectives and pressures and sensitivities will differ from your own. So once you've decided that settlement is potentially better than taking it forward, what do you do? I don't know if there are any poker players in here, but 7-2 offsuited is the absolute worst poker hand you can be dealt with in a game of Hold'em. Goodbye to your flushes and straights and so on. You're not going to do well. But it's worth pointing out that sometimes you will have a bad hand in disputes, and you need to work out how to manage it. Now, I'm not saying you should be bluffing when you have a bad hand, but there are ways to manage bad situations to get out of it better than if you just pressed ahead with the dispute, and that needs to inform your settlement strategy. What do you do when settling is worth it? Well, is it a sign of weakness? That's a common question that preys on everybody's mind. The answer is yes. Yeah, well, it might be a sign of weakness. It might give away weaknesses in your actual case if it goes to a decision, but often it doesn't affect it quite so much. You know, the other side, if they're well advised, may be able to spot these weaknesses. If it goes to a trial, maybe the evidence is going to come out anyway. So while there is a natural reticence saying, well, I don't want to look weak, like I want to settle it, or maybe if you're looking at a decision at the end of the day, it's not really going to affect that. But what it might affect is your prospects of settlement. Does it affect them? Well, again, maybe, but maybe not if you control it well and you craft your message and you go about it in the right way. And bear in mind, when you're trying to settle these things, you ultimately have control. You can settle. You don't have to. You can control what you do. When should you make the move? Well, there's rarely a perfect time. If you've got a weak claim, then you might think, oh, well, I don't want to show a sign of weakness. If you've got a strong claim, people will be saying, well, why are we bothering with settlement? We should press on. So there's never a perfect time, but there are some key good times, I think. And I divide them in sort of a couple of categories. I think the first category is all characterized by milestones in the procedure that have a kind of equivalence for the party. So you may have exchanged a letter before action and a response. You know what people's claims are, you know what their defense is. At that point, it may be a good time to approach the other side saying, look, we can all see what we've got here, we should try to explore settlement. Similarly, if you're into litigation, you've exchanged your particulars of claim and your defense, it's similar, but in a slightly more litigious setting. At that point, maybe it's a good time to consider settling. The other phase is after evidence. So we know there are fairly extensive duties of disclosure in English litigation. Once the parties have exchanged their documents, a lot more information is available. Maybe that's the right time to say to the other side, we know what we're dealing with here. We need to try to settle this. And similarly, if a case depends not on necessarily the documents, but on witness evidence and after exchange of witness statements. The bad times, I think, to start approaching settlement is just before all of these moments. It's either not good for you or your other side will not see any interest in doing it. So if you get the particulars and you're about to serve a defense, you don't want to be proposing settlement because the other side will just think you have definitely got something to hide. Similarly, if you receive that overture from the other side, you think, well, this is good times, so they don't want to serve their defense. There's clearly something going on. So that's a bad time, I think, to be proposing it. The other kind of milestones are outside the litigation. So there may be corporate decisions that are sort of trigger points in the litigation. Are you about to terminate your contract, like Ed and Guy were talking about? Are you about to terminate somebody? Is that a decision that's in the offing? Or is there some trigger event under the contract that's in the future? Or maybe it's something completely external to the dispute. Is it the end of an accounting period that might have some relevance to one party or another? In those situations, you might want to communicate to the other side in advance of that point. So sometimes the threat of doing it can be a pressure point that can bring people to settlement in a way that procedural milestones don't. If you're in active litigation, you can start settlement discussions whenever you like, but you need to be aware of your procedural timetable. That's going to roll on. But the courts are very, very receptive to parties saying, well, I need a stay for a number of weeks or a month or so. As long as the timetable to trial will accommodate it, the courts will generally accede to one party saying, well, we have agreed, we want to pause the timetable. So don't be afraid of pausing the litigation to give you a bit of breathing space if you would rather settle before proceeding with particular steps. More generally, there are advantages to settling early, and there are advantages to settling late. If you're early, the pros are obviously the costs are much lower. Parties haven't been entrenched in their positions. Your opponent won't necessarily know what your weaknesses are at that stage if you just exchange statements of case, and there's an increased chance of preserving the commercial relationship. Cons, obviously you may look weak early on, you don't know your opponent's weaknesses, and you might not know your strengths depending on your merits assessment, so you're operating in a little bit more of a fog. If you settle late, the reverse is true. You'll know more about the case, more costs, more entrenched positions, but then again, the threat of trial and a decision that's out of both parties' hands is looming, and it can focus people's attention. There's also the factor that the other side might just be exhausted by all of this. And while they're up for the fight early on, later on, they may be more inclined to settle. If you're a claimant, finally, bear in mind that the more you progress with the litigation, the more chance there is that the defendant might not have the money. And all of this might not have been worth it unless you protected yourself. One point on cultural differences. Just bear in mind, in some jurisdictions and in some sectors, settlement can be perceived differently. Sometimes litigation is perceived as a failure of negotiation. So the settlement might be much more difficult to do if you start proceedings or if you take a more aggressive stance. In other situations, litigation is just a precursor to negotiations, and people won't believe you unless you actually start proceedings. So you'll have to have sort of antennae out to different cultural situations. The last point I wanted to make is on credibility. I think that's fundamental to settlement. I think that is two aspects: consistency in your approach and authenticity in how you put yourself across. So that means don't make empty threats. Be prepared to carry them out. Make sure your threats are credible. And if you need to carry them out, actually do them. One of the worst things is threatening to do something, particularly seismic. The deadline passes and you do nothing, and your credibility has been diminished. Similarly, avoid red lines unless you really, really mean it. And don't forget that credibility is built up throughout the relationship and throughout the open parts of the litigation. So it's not just what you do by way of settlement, but it's what you do in the rest of the litigation that can affect the credibility in your settlement. The last thing I want to talk about is communicating settlement process. So once you've decided, yeah, you do want to communicate, how do you do it? Well, there are a number of options. Donna has spoken about prejudice, about privilege. One of them is without prejudice. Privilege, or the hilarious acronym I can't pronounce, is without prejudice, save as to costs. Obviously, if you want to do it save as to costs, that means that when a judge has decided this, they can see all the without prejudice save as to costs correspondence when it comes to deciding costs. That is useful because if you're making an offer without prejudice that you think you might beat, you'll want to show that to a court. But in other situations, you might want to go without prejudice if there's particularly sensitive issues, or if you're not making an offer in that sense, which I'll get to. It provides a broader umbrella, and you can proceed with negotiations safe in the knowledge that a judge will never see it. And again, from a cultural perspective, maybe that's going to be more attractive to the other side. They may be more receptive to this kind of discussion than if it's just without prejudice, save as to costs. As to who should communicate and who, and the only thing I'm going to say to this in advance of Richard's slot is it's not necessarily just the lawyers. In fact, there is sometimes an incentive of having your litigators not be your diplomat. It may be you as in-house counsel who have remained behind the scenes. You're the right person to commence or carry out settlement negotiations. Depending on the commercial setting, it could be your CEO or some other member of management who can bring a sense of independence, a sense of commerciality to the situation. Or in more complicated cases, you may have a specifically appointed negotiator who's not necessarily a lawyer, but will be able to handle the negotiations. And this will all depend on the type of settlement that you are approaching. In terms of mechanisms, there are a number. I think they broadly divide into three. I mean, firstly, meetings, a real-time meeting, parties in the same room, that can have advantages. It's easier for you to set out the context for your offer. It's easier for you to gauge the response of the other side, either just before you're making your offer or just after you get an immediate reaction, which you don't necessarily get in the other context. It allows for a quicker counter offer, a back and forth. If you feel there is a deal to be done and the parties might be quite close, then maybe you can get there in a meeting. It also gives the opportunity for breakout discussions and what I've called the sort of corridor chat. Don't underestimate the power. If you're in the room, you have breakout rooms, but then again, if you're about to leave the meeting or you're breaking for some reason, you could have a quiet word with your opposite number, and it just sort of breaks the format. You can break impasses, which you can't necessarily get in other situations. Correspondence is the sort of counterparty of that. It's more controllable. You'll send a letter or whatever. It's more craftable. It's often cheaper because you're not spending, half a day or a day, everybody in the same room. You just send your letter out, but there's no way to assess the reaction to it. So you'll send your letter out and then nothing comes back and you don't know how it's been received. And that might be fine if that's the kind of message you want to give, but it might not be. I put in video calls. That tends to be fine. Sometimes it's necessary if we're in lockdown, but I tend to think it's kind of the worst of both worlds. You don't quite get all the advantages of a written communication. You don't quite get all the advantages of an in-person meeting. And finally, there's mechanisms for Part 36 offers. This is almost a talk in itself, but there is formal mechanism within the CPR where you can make an offer. It gives you cost protection if you go on to beat that offer at trial, slightly different consequences for claimants and defendants. It also gives you enhanced interest protection. If you're a claimant, it gives you an additional amount. From the defendant side, if you're making a Part 36 offer, you need to remember that it does commit you to paying the other side's costs up to a certain point, and the position flips if they don't accept it. The last thing I would say is that when you are conducting these kind of settlement discussions, it doesn't have to contain an offer. It needs to be confidential. It needs to be for the genuine purpose of trying to resolve the dispute. But you could do something a little bit more sophisticated. Early on in the dispute, you could decide it's a good idea to establish lines of communication with the other side, just to say, we have this dispute, we're confident of our position, we're going to proceed, but at some point we may need to think about settlement. If we want to talk about it, then we should talk about it and signal a willingness to discuss it without really affecting your outcomes at trial and without committing yourself to doing anything that might be perceived as a sign of weakness. And you may wish to invite, depending on the kind of case it is, some sort of discursive call, a willingness to listen to what the other side is trying to say. If you think there are going to be high emotions on their side that are not going to come out in a dry legal document or a solicitor's letter, you may want to say, look, I'm happy to listen. I'm happy to hear your context of things. No harm in doing that. And they get to vent, they get to express things, and you might reach an understanding that gives you a space for settlement. Similarly, on the reverse, you might want to have a nuanced conversation about the context for you, to your advantage. So you may just want to call to explain your position in a without prejudice context, not making an offer, but just to convey what is going on. I'm now going to hand over to Richard, who's going to talk about a slightly more formalized mechanism that we may know, which is mediation.
I was just about to give you the secret sauce of how to actually settle, but I feel like we are running long on time, so I'll just have to give you the hints and tips that I can get across, and maybe we can discuss in the break. As Dan says, one of the options for a settlement process is mediation. The reason we chose to focus on mediation as opposed to one of the other mechanisms is that whilst all of the mechanisms can work, once parties are either approaching litigation or have actually taken the steps to commence litigation, mediation tends to be the one where you can get a result perhaps when you thought you might not. All of the other things can work, and it's horses for courses, but if you feel like you might not be able to settle the case, mediation is worth thinking about. Why is that? I'm going to give you advantages and disadvantages together, because they're really flip side of the same coin. But just pausing first, I'm sure some of you have experience of mediation, others will have none or less. Broadly speaking, what is it? Importantly, it is consensual. It is just two or more parties agreeing to meet to try to negotiate a resolution to a dispute. There is no adjudicated outcome. You are not bound by anything in a mediation unless you agree to be. What you are obliged to do is to consider mediation. There can be costs and other consequences if you flat out refuse to consider mediation. That can include considering it and saying, I don't want to mediate, as long as that's a legitimate approach. Once you have started to communicate about mediation and or engaged in mediation, the obligation therefore is just to do it in a way where you are engaged. If you pay lip service to it, again, there could be consequences for that. Why might you decide to do it? As I indicated, the prospects of actually reaching a settlement can be higher in mediation than exchanging correspondence or having calls. As I say, it really depends on the case, but there's something about mediation that focuses minds. A downside to that is that there can sometimes be a perception that there is pressure to settle, particularly for those that aren't so established experience in mediation. Even for people that know that there's no pressure to settle, being in a room for 10 or 12 hours and feeling that everyone has made the effort to be there, including the cost of a mediation, which are not small, can create pressure. There are various other things. I won't go through all of them given time, but essentially a mediation does put you in a different position with your opponents. You're, broadly speaking, in a room together, can do a remote mediation. People have made the effort, people have prepared, and there is an opportunity to see the whites of each other's eyes. It does lead to settlement quite often, and quite often that is because you have spoken directly to your client on the other side or former customer, or you have managed to say something which perhaps their lawyers didn't say to them, and is perhaps news, or at least they've heard it in a different way. Preparing for a mediation is essential. It's probably the thing that I would ask you to take away from today. It is really amazing how often you get the impression that the other side to mediation have turned up and not given it quite the same level of thought that you have. There can be a temptation to think of mediation as an end of the dispute, and therefore to not do the things that we would always suggest you do in terms of preparation. There's some simple things. I could speak about them at length, but I won't. Things like choosing the right mediator, setting out your case in your position paper and doing that properly. And again, this goes to preparation generally. Take the time to put forward your best case, and that may not necessarily be your best legal case, although it should include that in most circumstances. There may be other factors you want to include. Rehearsals are always useful. Venue, I don't think matters too much. People tend to worry a great deal about it. I think there are benefits and detriments to having a home venue. I sometimes quite like going to the opposing lawyers' offices, particularly if you feel that you want to be the party that isn't leading, because it allows you to effectively turn up and leave when you like, whereas there can be pressure if you're the home team to stick around. As Dan has mentioned, attendees are critical. We often talk about the difference between having a barrister at a mediation and not. Having a barrister there can sometimes lead the parties down the same old paths, because people then tend to focus on the legal arguments. Sometimes it can be very useful, particularly if there's a discrete point where you feel you have the better of the argument, the other side don't really accept it, but perhaps their lawyers aren't doing a good enough job of explaining it. I hope no one would ever say that about us. Authorities settle, I won't go into detail, but worth thinking about from the other side perspective as much as your own. Ideally, you would have authority at mediation, so a human who could make the decision, but perfectly acceptable to make a phone call as long as there's good reasons for it. A draft settlement agreement, which I'm going to come on to, again, another key takeaway, we would always draft a settlement agreement before a mediation, at the very least key points, sometimes doing the heavy drafting. I'll come back to why that is shortly. Walk away red lines. Certainly wouldn't suggest that you have definitive red lines that will never change, but you should think about it. And the principle behind the red lines before the mediation should inform the decision you make at the mediation. Things may change, but you should understand why you've changed your position. Think very carefully about that. The last thing is somewhat tactical. The worst thing to do for any settlement process, and in particular mediation, is to drop the ball on the litigation, to stop doing the things that you need to do to succeed at trial, not least because it means that you have to do more work after the mediation, but it can also send the wrong signal to the other side. A better approach, if the cost analysis can bear it, is to do everything you need to do before the mediation. Better still, make an application or serve a document the other side needs to respond to after the mediation. It's amazing how that does play on minds. The legal team, the client, the hassle involving senior people in signing a witness statement, for example. If those things can be after a mediation, it can help you. What if it fails? I'll come on to the agreement that you might execute if you succeed, but what if it fails? Well, trial, potentially, but it's really not as simple as that. One of the reasons that mediation, I think, has been so successful is because it has moved on from a one-day, one-stop shop situation. People now do see it as part of the process. And another key takeaway from me is, is it really over? And think about that before the mediation. There is sometimes this pressure to settle, but you don't need to feel that pressure if you feel like you've made good progress at the mediation. Perfectly acceptable to draw stumps, walk away, but in the knowledge that you can come back. And it is quite often the case that the mediator will stay involved with the parties. There can be phone calls, mini mediations, mediation 2, 3, 4 if necessary. But I have found that quite often having a mediation breaks the back and does start people thinking about settlement. So what if you do actually manage to reach an in-principle agreement? Again, this sounds slightly basic and I will go through these very quickly, but key questions. What are you settling and with whom? If you are granting releases, who are you granting them to? There have been a number of cases where people think that they've settled with their opposing party, but because of the desire to be complete, wording which refers to affiliates or subsidiaries or related parties has effectively come around and stopped that party settling with others that they didn't have in contemplation at all, because they've agreed it in a bilateral settlement to which a third party can claim to have an interest, or the opposing party has a right to enforce it for some reason. Payment, again, something that probably appears in most settlements, not all. The key point with payment is just to consider whether or not it's part of the main agreement or whether it should be a condition precedent. Particularly important where you've had a failure to pay as the cause of your dispute, often happens in a fraud situation. The parties can spend a lot of time negotiating settlement agreements, entering into settlement agreements, and then fighting because that party was never ever going to pay. Entering into the settlement was just part of their strategy to kick the can down the road. Parties I've talked about a little bit. Releases, indemnities, and undertakings could be a separate talk. The short point here is that when you are considering the parties that you are going to release, it's not only a question of knowing who you're going to release claims against, but also the unknowns. In any settlement process, it is essential that you spend a bit of time thinking about the rest of the dispute, other parties. Is this the final deal that we want to do? And is there anything that we want to carve out? And always best, if you have a concern about a third party, to say it expressly. We release these claims, but we do not release these other claims. Effect on proceedings I've talked about a little bit. Legal costs should be included. If they're not included and the agreement is silent, then you potentially have a difficult situation where you have to go back to the court and ask for your costs, and they're not very keen on doing that, and will try to find a way not to do it if they can. Confidentiality, I'll say a little bit about privilege, as we've spoken about that earlier. All settlement communications are potentially subject to without prejudice privilege if they are genuine attempts to settle, and if you say so expressly, they could be subject to without prejudice save as to costs privilege. In the context of a mediation, you're at least in WP territory for the actual mediation itself. You could seek to make it a WP save as to costs, but that can be complicated. On confidentiality, there is usually a provision in a mediation agreement that most mediators will have and will ask you to sign that says that everything to do with the mediation is confidential. So you have effectively a contractual confidentiality obligation as well. One of the exceptions to that can be public statements, something to negotiate at the mediation. If you've otherwise agreed to confidentiality, it's not very helpful to come back after the mediation and a signed agreement and say, but we need to tell someone. Usually you'll be told where to go. Enforcement, again, could be a subject on its own. Settlement usually means the end of proceedings. It doesn't necessarily need to be the end of the formal proceedings on the court file. If you reach a simple settlement where there's a payment obligation and you don't make it a condition precedent, you might find yourself in a situation where payment hasn't been made and you want to go back to court to enforce your contract. You can do that in a way where you can just continue in the existing proceedings without starting a new claim. The formal mechanism is called a Tomlin order, and that allows you to have a simple order, confidential, which just says the parties have settled on terms in a schedule, and that schedule is more or less confidential. Different courts treat it in different ways, but you can either append the settlement agreement and say that it's confidential, or better still, just don't append the agreement at all. I'm going to summarize a little bit on settlement before I finish, but just very quickly. Dispute resolution clauses, I'm not going to go through this, but something to think about. It is relevant to settlement, depending on which forum you're in. Different sort of considerations apply, but it's really about the process that the parties have to go through in order to settle. I want to just focus on, and that really is about escalation provisions. Becoming quite common now to have escalation provisions. One of the things on the previous slide is don't have conflicting clauses. Again, that seems to be pretty common as well. But escalation provisions are intended to give the parties the opportunity to work through, for example, some negotiations or a CEO escalation before you have to, or can rather, commence litigation, and you could have a mediation obligation and others. Proceed with caution. It can be right, but it can be very restrictive. And if you're the party in the wrong and you just want your contractual or court remedy as soon as possible, having the obligation to go through these hoops can be quite frustrating. And it can lead to a bit of satellite correspondence and potentially satellite litigation if you proceed and the other side say you don't. Injunctions are also another area, although broadly speaking, if it's urgent, you should be able to go for an injunction. Constraints I've mentioned. The real question is what's best for you, and you can talk to us about that if there's any questions. In terms of a summary, I think the key points that I've tried to get across are that settlement is something that should be considered throughout a case at any point, and it includes when you take your initial decision as to whether or not to terminate or start making investigations. Have an eye on where this is headed. You can only get from the court sort of one-dimensional settlement of the dispute in front of you. At mediation and in sort of inter-parties correspondence and discussions, you can be more creative. And I think that's one thing that we see, particularly at mediations. Once the parties are there, you quite often hear someone say, well, actually, how about this other deal that we've been talking about in the past? If we do that deal now, then maybe we're not so bothered about sticking to our rights on this one.